Hello, and welcome back to Retire with Oakleaf. My name is Matt Booth-Willett, a certified financial planner and an enrolled agent. First and foremost, as I do in every video in a very annoying way, please don't forget to subscribe to our channel to stay up to date with content. We do try and time it with certain rule changes or times of the year when we know there are areas to pay extra special attention to. But in any case, please don't forget to subscribe, like the video, engage with us, and of course, as always, if you have any questions at all, whether they're general or if they're more personal to your situation, please do not hesitate to reach out to us here at Oakleaf. Our contact information is in the bio. You can also find all of us on our social media platforms as well. So, to jump into today's topic, I wanted to go through some of the top traps we typically see people fall into with estate planning, whether that's before they put documents in place, after they've put documents in place, and when they're reviewing them. First and foremost, having an estate plan is step one. So if one does not have an estate plan, we typically will say you should go get one and work with a qualified estate planning attorney to do it. As a blanket statement here, anything we discuss is not legal advice or tax advice by any means. This is just meant to be general education and discuss some pitfalls that we typically see folks fall into in this area. So to begin, a basic estate plan, as we refer to it, is wills, medical directives, and powers of attorney, in addition to beneficiary designations on any accounts you have. So very simply, wills are what you possessions you bequest to people. If you have your house in your will, where that gets distributed to who, when. In addition to that, medical directives, powers of attorney, very simply give somebody who's not yourself the power to make medical or financial decisions for you if you become incapacitated. Beneficiary designations are the area that we typically see are most overlooked when it comes to estate planning. When estate planning comes into your mind, you think of wills, think of somebody passing, think of maybe somebody who's older or needs some type of help, some type of care. But beneficiary designations are something that we can all control. So this is on your retirement accounts at work. This is your individual retirement accounts. These are your bank accounts, your individual investment accounts. Anything of that kind can have a beneficiary on it, and that ensures that it goes to the right person in the right place. So each year we do encourage folks to look these over and make sure that they are the right person, they are the right percentage. If you have children that are now becoming the age of majority and can now inherit these accounts and not be minors, if you'd like to add them as primary or contingent beneficiaries. But again, first and foremost, ensuring that these are accurate and up to date. We've seen situations over the years where the primary beneficiary has passed away. We've seen situations where somebody gets divorced and their ex-spouse is still the primary beneficiary on the retirement account where that was not the intention. We've also unfortunately seen some situations where beneficiaries have been left blank. The account holder passes away and it becomes that much more difficult to obtain the funds in the account and distribute them and also ensure they go to the person that it was intended for. So enough on beneficiaries for today, but that is one of the most important areas that we see people overlook. And quite frankly, just given the easeability of going in your account and updating them, it is one of the most feasible areas that you can take advantage of from an estate plan standpoint. So moving into more of the estate planning realm, once you have your wills, medical directives, powers of attorney in place, the biggest mistake we see people make is they don't review them. They put them in place when they are first married to their spouse, or they have children, or they just bought their first house, some life event happens, and then they don't look at them for the next 5, 10, 15, 20 years. So during that time frame, your life evolves, you and your spouse grow, your children grow, and there are a lot of different life dynamics that weren't present when you put those in place. So it's really important to just review them. We typically say every 3 to 5 years to ensure that all elections and wishes are accurate. In conjunction with that, sometimes people do reach a point in their situation where a type of trust becomes an option. And we, again, typically say work with your estate planning attorney to determine if this is viable for you. If so, what type of trust? Really blanket term here. There's irrevocable trusts, meaning non-changeable, and revocable trusts, meaning changeable. So Those two differences are very important to know, as we have seen people not understand what type of trust they were putting in place, and this can create some unintentional headaches, confusion, potentially unexpected family dynamics down the road as well. So again, first and foremost, understanding with an attorney if a trust makes sense, and if so, what kind. Now, once you go through this process to put your trust in place, it is really important to fund it. So we have unfortunately come across situations where clients have put a revocable trust in place and it was never funded. And at that point, I use the very corny joke, but also very true. It's just a really expensive piece of paper or really expensive collection of papers, because you paid a lot of money to have that trust put in place, but unfortunately there's nothing that's in it that's funded that's going to follow that trust document. So you want to make sure you work with your attorney and your financial team to ensure that whatever is intended to go into that trust or at your passing or be retitled into that trust is done so in a very timely fashion to, again, ensure that your wishes are abided by and ensure that all directions are followed per the attorney. The last pitfall I want to hit on here that relates to the trust is that these aren't reviewed. So sometimes in revocable trusts, there are age restrictions put on receiving assets from the trust if you have minor children, or if there is a family member or child that has an addiction or a unfortunate medical condition, that there are specifications that are outlined that were intended to be followed at the time, and they've grown out of them, or circumstances have changed, and that document is still as abiding by the rules that were put in place when the document was created, and now those rules may not apply. So it's really important to just review that trust document, ensure that everything is up to your wishes, and if it isn't, please engage with your estate planning attorney in conjunction with your financial planning team to ensure that the appropriate updates are made, especially as tax laws change. So the last section of this updating that I'm going to hammer on is making sure that there is language in your trust that supports current tax laws. And again, working with your attorney on this is crucial, because there were some changes in 2020 around inherited IRAs, and this created a different set of circumstances for administering IRAs in an estate standpoint, especially if your trust was the beneficiary of that IRA. So long story short, to summarize, make sure that you have an estate plan in place, or you're at least planning to put one in place. To do that, make sure you're working with a qualified estate planning attorney, somebody who is going to listen to your needs and be able to create a plan that is specific to you and your situation. Thirdly, some of the lowest hanging fruit that we believe is lumped into the estate plan, your beneficiary designations. Make sure those are up to date and accurate. Last one is ensuring that these documents are reviewed every 3 to 5 years to ensure wishes are accurate, to ensure that the documents are up to date with recent tax law changes, and again, to ensure that they are properly funded. Again, we've unfortunately seen situations where these documents are put in place, a lot of money spent to do so, and they are never funded, so they may never be used in the fashion they were intended to. So of course, any questions at all, please feel free to reach out to us here through the channel, through our website, which again is linked in the bio down below, or on our social media channels. We're always happy to help and answer questions, whether they're very general or if they're specific to your situation. We will absolutely schedule time for us to chat. Lastly, this is not legal or tax advice. Make sure you are engaging with your personal team to ensure that what you are thinking of doing or what somebody told you you should do or think about is actually appropriate for your situation. With that said, closing out today, Matt Booth-Follett from Retire with Oakleaf.